Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors. And this week's contract tip has to do with you, the agent, as the principal, meaning you, the agent, as either someone who is going to buy, sell, rent, lease, or exchange real property. So there is a lot to this topic. I'm going to divide it up into three sections. One, agent as principal for just buying or selling property for yourself. Second one, agent as principal if you are inactive. So you are licensed, but your license is currently inactive with the Real Estate Commission. And the third topic will be agent as principal as a property manager. So in other words, if you have rental property that you own, what you are and are not allowed to do as a licensee with rental property. So let's start with the first one. This is all license law, and there are various sections of the license law under the GREC rules, as well as the official code annotated Georgia law books in Georgia law. So the first thing I'm going to start with is the GREC law, agent as principal, and that is GREC 520-1-11. And we should start at the very beginning. Basically, to paraphrase what that rule is, you as a licensee cannot do anything with respect to real property, again, buy, sell, lease, rent, or exchange, without first notifying your broker of in writing of your intent to do so and gaining your broker's consent. That means that, well, let me read you what the law says. The actual GREC rule is, no licensee shall be permitted to list, sell, buy, exchange, rent, lease, or option, or offer to list, sell, buy, exchange, rent, lease, or option real estate, either in individual or in multiple parcels in the licensee's own name, or in the name of any other firm or entity in which the licensee is an officer, employee, beneficiary, or member of such firm or entity acting as principal, without first advising in writing the broker for whom the real estate licensee is acting. So what this means is, if you as an individual, or if you are a member of an LLC, a corporation, or anything along those lines, this applies to you too. So you investor agents, this applies to you too, buying, selling, so forth and so on, property in the LLC's name in which you are a member. You cannot sign, you must first advise the broker. What that means is you cannot sign a listing agreement, a buyer brokerage agreement, or enter into a purchase and sale agreement or rental agreement without first notifying your broker in writing of your intent to do so. Again, this has to do with you as an investor as well. So before you sign on that contract, send in writing a note to your broker advising them. That is the first part. And then the question always comes up, well, if this is for me, why do I have to tell my broker that I am marketing a property that I own, especially if I'm not paying a commission? So for example, if I am the principal and I am not going to receive or pay a commission, what business is it of my broker? Well, the law, OCGA section 43-40-29C, basically what that states is, in order to protect the public, it requires a licensee to comply with its provisions, whether acting as agent or as principal. So in other words, your broker is required to review all of your activity because you now hold a license issued to you by the state of Georgia, and that license is being held by a broker who holds the liability for your actions. So your actions are that of a real estate licensee, even if you are also the principal. But the broker, though, still must go through the broker, and the broker has to review all of your activities for compliance with the law. And it doesn't matter if you are the principal or the agent or both, and the commission that you receive or don't receive, again, that has nothing to do with license law. That has to do with your relationship with you and your broker and whatever policies your broker may or may not have. So that's in general, and that has to do with all real estate activities you as a licensee. Basically, now that you hold a license, anything you do with real property must go through your broker, regardless of any financial benefits or commissions earned or commissions not taken. That has nothing to do with it. Now, for you actually just buying or selling a property for yourself, whether it be a personal residence for yourself or an investment property, again, same thing applies, and that must go through your broker. And depending on your broker's policies and procedures, for example, you would have to upload it into Paperless Pipeline, create a transaction, and it has to run through a full compliance check, just like any other transaction would have to. Also, in general, when you are acting as principal, you must adhere to all of the GREC advertising laws and guidelines. And so that would be under all of those advertising requirements is GREC Rule 520-1-.09. That's a whole nother video, the advertising and marketing. But basically, it can't be misleading. It must run under the direct supervision of your broker, and advertising a specific property. There's all the guidelines about the names and the phone numbers and size, prominence, and frequency. But specifically, GREC Rule 520-1-.09 subparagraph 8 states that if you wish to advertise real estate that you own and you are not under a brokerage engagement, the license law says that you may do so as long as the broker has been notified in writing and the broker gives written consent to advertise that specific property and approves of the advertising. So again, you need to check with your broker. If you are a maximum one agent, our policy is that all listings must run through the brokerage. You cannot act as a for sale by owner when you are an agent. Again, if you are not a maximum one agent, you will have to check with your own broker. But regardless of the advertising or regardless of running it through a brokerage engagement or not, that is a broker policy decision. Regardless whatever your broker allows you to do, whether or not you are under a brokerage engagement with the brokerage or not, you must disclose in all marketing and advertising, all purchase and sale contracts, everything, that you are a licensed agent in the state of Georgia, and with your real estate license number, or you must disclose the fact that you do have information and education and training above and beyond the public who does not hold a real estate license. So that basically is in general, if you're buying or selling or leasing or renting property. If you are an inactive licensee, all of that holds true, except obviously you're not working with a broker, so you're not going to turn it into a broker because you're not working with a broker and there's no compliance review to go through. However, you still hold a real estate license in the state of Georgia. Therefore, the one part that applies is, and this is OCGA 43-40-12 subparagraph G, states that even if you have an inactive license, you must disclose that you are a licensed real estate agent. So either giving your license number or just disclosing that you are a licensed real estate agent in the state of Georgia. You must do that because even if you are inactive, you still have the license. You're just not hanging it with an active broker right now. And you do have education, training, and knowledge above and beyond someone in the public who does not hold a real estate license. Now, the third section has to do with you as a licensee. If you own rental property, what about the escrow money? And escrow money is two parts. It is security deposits and it is rent. So there's a little bit more to that. But basically, if you own property, the law says that you may hold trust money, you may hold security deposits if there are a couple of qualifiers for that. The deed to the house is in your name only. If the deed is owned by an entity like an LLC or corporation, you must be the sole member of that LLC or the sole entity of that corporation. If you are not 100% owner of that property, you may not hold security deposits. You may not hold any type of trust money or escrow money, period, per the law. So if you and a spouse and a friend and a significant other, a business partner, if the two of you are on title or more are on title to a property, you may not hold any type of trust money, period. It must be held by your real estate broker or by a property management company. Now, if you are in a position where you are the 100% sole owner of the property, license law allows for you to hold escrow money. However, you must hold it in a trust account. You must adhere to all the license laws pertaining to trust accounts. That's a whole nother video. Please go go take license law class so you learn all about that. But most importantly is that trust account must be registered with the Georgia Real Estate Commission, and the only one that can register that account is your broker. So you must check first with your broker's policy. There are, even though it's allowed by law, by real estate license law, that if you're sole owner, you can hold a trust account. There are many, many brokerages that will not allow you to hold your own trust money. It must be held in the trust account of the brokerage, or they would require that you hire a third-party property management company to hold that. If your broker does, again, the trust account must comply with all of the correct license laws regarding trust accounts. With another party, so let's say you and a business partner, spouse, so forth and so on. Again, if you are a co-owner of a property and the other owner of the property does not hold a real estate license, not only must the security deposit, you can't hold your own security deposit, at that point you can't collect your own rent either, because rent is considered trust money as it comes in from the tenant, because it is not yours solely, and it has to be divvied up from the tenant, and then it goes, well, let me just read what it says. The associate broker must place both security deposits and rental payments in a trust account. The rental payments cannot be paid directly to the associate broker because he owns a property with a third party, and all money is technically not his or hers. Security deposits cannot be held in the associate broker's trust account because he or she owns the property with another unlicensed person. The associate broker must inform his or her broker that he or she has personal real estate and give trust funds to the broker for safekeeping. Cannot keep any trust funds such as security deposits or rental payments in any personal checking account. So again, you need to check with your own broker and their policies regarding the investment property that you have as an agent, especially if you have rental properties with tenants who have put in a security deposit and are paying rent, if you are not the sole owner of the property. Even if you are the sole owner of the property, you still need to check with your broker regarding their policies. So again, there was a lot to this topic. Please go take the license law class where these issues are discussed more in depth. Please check with your own specific broker regarding any specific situations you may have, and I hope this contract tip helped you out. Thank you so much for watching. Again, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education. Come here, pups. Say hello. Say hey. Can't see them, but the puppies are here.